Well, hello everyone out there in the online virtual world. Thank you for joining in this live. Shout out to everybody on Facebook, also LinkedIn and YouTube. I'm excited about this particular uh, webinar where we're doing, or live, I guess, however you want to call it. This month is August is Make a Will month, and tonight my very special guest, my friend, my sister, all the way in South Florida. She is a author. She's an attorney. She's a podcaster. She is an educator. And her area of expertise in law, she's also a business owner, entrepreneur, is estate, estate planning and specifically in the real estate arena. She also she's an aunt. She's very, what's the word? Very involved in special needs causes and awareness. So I want to present to some and introduce to others Sandy Boisrond. Sandy, thank you for allowing us to have this 4 weeks. This is going to be a 4 week series.
This is going to be a full series.
Yes, on estate planning. And also, everybody that's watching, if you're watching live, do me a favor, give me a hashtag live, tell me where you're from. And then if you're watching on the replay, hashtag replay and tell me where you're from. All right, Sandy. So let's get to it. So it's Make a Will month. Okay. And I think we just learned about this. Was it last year that August was Make a Will month, or was it the year before that we learned?
I feel like it was the year before because we'd been talking about different like awareness months and we were trying to figure out what we were going to do for different events. So I think it was the year before.
Gotcha. Okay, cool. All right. So what is something I want to start this off and then you can go into what you have. But I came up with some questions, and one of the questions I wanted to ask is what are some common misconceptions? What are some of the biggest misconceptions people have about estate planning, and how can they avoid these pitfalls?
I think one of the biggest things that I deal with on a regular basis is people not understanding the different types of tools that you can use as part of your estate plan. Many times people think an estate plan is just one thing, or they kind of have a misunderstanding of the types of documents that are needed for different types of things.
Okay.
Let me give an example. I often get a call about a living will. I need to get a living will done.
Mm-hmm.
And what folks don't realize is a living will is not what we know to be a will or a last will and testament.
Okay.
A living will is actually a healthcare document. It's a document that you utilize to express who you want to handle your final affairs when it comes to your medical needs, when you become incapacitated, or if you're in a situation where you're in the hospital and someone needs to speak on your behalf. So you're able to say, look, I don't want to be resuscitated if something happens.
Okay.
And these are the people that I want to be able to access my medical information. Oftentimes a living will, not a will, a living will, the healthcare document, is used in a way to help someone have a power of attorney for their medical needs. And the other thing is understanding that the document is created by the person who has the power to create it, right? So
Okay.
I can't create this document for my mother. I can't create this document for my son or for my, my aunt or uncle. Like, the person who wants to give the power to someone else is the person that can do that. So
Okay.
living will versus will is my first and most common thing, because people don't understand that a living will is a medical document. It's your medical power of attorney. And a last will and testament is what we actually know as a will.
So what happens? Let's go back to this same scenario. So what happens if a person calls you and the person is incapacitated and they're asking for a living will? What legally can a person do? What I mean, Glenn, hey Glenn, good to see you on LinkedIn. Glenn asked, can it be contested? I guess that's kind of what my question I wanted to ask. Can it be contested?
So oftentimes when it comes to anything dealing with documents or rights and powers, someone can make an objection. Someone can contest it. Doesn't mean that they're going to be on the winning side, but someone could contest it depending on what the reasoning is. So as example, let's say someone believes that a stranger, maybe a caregiver, took their mother to go and get a healthcare power of attorney or a living will done, giving the healthcare provider, the caregiver, the power to make decisions, right? And the person is incapacitated and they're unable to make decisions for themselves. Well, first of all, that document would not be valid because you don't have a person that was capable or with the capacity to make that decision.
Okay.
And, the second thing is understanding that whenever these types of documents are created, the person has to have their full capabilities.
Okay.
You have to have their faculties about them. So you can't just take someone somewhere and put their hand on the paper to sign it, right? They have to have the ability to communicate. This is my intention. I want this person to handle my medical affairs. I want this person to make decisions about my healthcare needs and procedures.
Okay. So let's use kind of the same scenario here. And you work in this area, so special needs. So what happens? So when they turn an adult, so it's a child, a minor, and they turn an adult, they may not have all. So can you explain? You understand what I'm trying to ask?
So I'm in a perfect position to answer that because my nephew is autistic and he is going to be 18 this year.
Okay.
Please pray for me.
Okay.
So my nephew's autistic. He's non-speaking. He has a need for basically round the clock attention and support. He's unable to make medical decisions for himself. He's unable to make financial decisions for himself. First of all, he's not able to communicate. He doesn't verbally communicate. He uses a device, and that device is for very limited things. So using my nephew as a perfect example, the moment that he turns 18, we have to set up a guardianship for him. Now, I use the term set up, but I want to really say go through a court process to have a guardianship established. And basically, guardianship is a very strange thing because it has two parts. The first part is the capacity determination. The court has to make a legal determination that a person is incapacitated. That is through a mental health court. At least here in South Florida, that's how it's done. There's a mental health piece, and then there is the guardianship piece that goes through our probate courts. So the mental health piece, first of all, the moment that you file the petition to determine incapacity, you're going to have an attorney appointed to represent the alleged incapacitated person, in this case, my nephew. So he will have an attorney appointed to represent his interests.
Gotcha.
Then there will be a committee of physicians appointed to do an evaluation of him. You'll likely have a medical physician. You may have somebody like a psychiatrist, and then you may have a third party, like another type of provider that is going to do an evaluation, and they're going to say either this person is not incapacitated, this person is partially incapacitated, or this person is totally incapacitated. Once you get that decision from the mental health piece and you have a capacity determination, now there will be a response to your petition for guardianship, which is to determine the person who will serve as the guardian. Now, note, just because you are a family member or parent does not mean that you will be the guardian. There are rules in different states for the requirements or qualifications to be a guardian. In Florida, for example, you of course would have to be 18 or over, and you cannot have a felony conviction in your background, in particular a felony that has to do with the inability to handle funds or any kind of fraud or misrepresentation. So your background matters, and your ability to manage money matters, because they tend to pull things like credit reports and look at your scores and things like that to see, are you able to manage your own before they appoint you? So The guardianship process has like different layers and steps. There's an application, there's likely some background screening, there's of course the petition that's done, and then there's a hearing. Okay. Oftentimes here in South Florida and much of parts of Florida, once you have that mental health hearing, you're usually before the same judge to do the guardianship part at the same time. Okay.
Oh, Sandy, before you go, I want a station identification break. First of all, if you're watching live, give us a hashtag live. Tell us where you're from. If you're watching on the replay, give us a hashtag replay. We want to emphasize this is for information purposes only. She is not giving legal advice or financial advice. This is for informational purposes only. All right, go ahead, Sandy.
That's absolute. And I'm going to say to you, I am an attorney. I'm a lawyer, whichever word you want to choose, but I'm not your lawyer. So please understand that I'm only here to do the education, because in fact, it's not like I'm trying to look for cases or anything right now. I'm in a different space right now. But I do want folks to be educated about this area in particular, because many in our community do not have our affairs in order. And what that leads to is very lengthy processes in the probate courts and very lengthy processes in the guardianship court. And in fact, I mean, I have a stack right now of things that have been around for a minute that we're trying to kind of get pushed forward. So you just want to protect yourself and not be in a situation where you have to be stressed over this.
Now, Sandy, you just said something that's very powerful. You said many of us, and I'm gonna say this, and then Glenn asked another question, but I want to say this so I won't forget. Many of us in our community don't have our affairs in others. I want you to address that in more details. But Glenn asked a question. He said, "Can a power of attorney override a living will's person's choice to not resuscitate?"
So Glenn, thank you for that question. And that's a really good one, because here's another thing with distinguishing between the types of documents. So a living will is a healthcare power of attorney. And then there's something else called a durable power of attorney, or in different states, there may be a different name, but it's basically a financial power of attorney. So you have two different types, a medical power of attorney and a financial power of attorney. The power of attorney for your healthcare is going to have language related pretty much only to your healthcare. The power of attorney that you handle for your financials will typically have language dealing with things like banking, investments, real estate, anything that may have a title or an ownership interest or a labeling where your name is attached to it. And so the two don't really go in the same lane. So what I will say though is, and I'm glad you asked this next question, because he's asked the exact question that I was going to go to. What is the difference between a power of attorney and a guardianship? Technically speaking, there's not really a difference aside from the fact that when you have a power of attorney, you don't go through a court process. You create your power of attorney while you have the capacity, and you give the powers to the individuals that you want. And in your power of attorney, you may even list, if this person is unable to, or passes away, or ceases to serve, here are some other alternates that I have who can step in and serve as my power of attorney. A guardianship, however, comes into play in the event that you do not have what they call advanced directives, which in this case would be like a power of attorney or living will or things like that. Or they have advanced directives, but the advanced directives are silent on certain issues. Guardianship has two phases, or better yet, two lanes. You have guardianship of the person, which deals with the medical care, which deals with where the person lives and their day-to-day activities of daily living. And then you have the guardianship of the property, which handles everything: bank accounts, investment accounts, real estate, anything that has a financial interest in mind. And so a power of attorney and a guardianship are kind of like two different sides of the same coin. They both are addressing incapacity or an inability to handle your medical or financial affairs. So on the court side, you're dealing with guardianship of the person or guardianship of the property or guardianship of both. On the I did it beforehand side, or the estate planning side, you're dealing with, I'm creating my power of attorney while I'm fully capable to make decisions for myself and I can make whatever decisions I want and identify whoever the persons are that I want outside of courts. Oh, we got someone live from Texas.
Hey, welcome, Rhonda. Uh, so, uh, so basically, the difference between the power of attorney is in the guardianship. Guardianship, you have to go through the court. The power of attorney is, if it's done properly, they create it while they are living in their right legal capacity,
Right.
and that's the main two. Technically, they're the same, but that's the main two differences. Am I understanding that correctly?
Absolute. And the key is to understand that when you do your estate planning properly and you cover your bases, there's going to be minimal or no need for court process. So if I do my estate planning and I handle all my affairs and I pass away, I'm not likely going to end up in a probate court process. If I do my estate planning and identify my intentions while I'm living, but I become incapacitated, there won't be a need for my family to now seek out a court to get orders to handle my affairs because I already have my house in order.
So I want to talk about DMX, Prince, Aretha Franklin, Chasman Boseman. I want to talk about them. Glenn got another question, and can a family regain? Let me put this question up there. Can a family regain power of attorney after a state appointed a guardianship?
Ooh, that would require a termination of the guardianship for that to happen. I mean, the person would have had to regain capacity. So if your question is about a situation like this, where let's say the person had a stroke and they were incapacitated for a period of time and they did not have their affairs in order, and you had to go and establish a guardianship while they were going through their recovery period, but then they regained the ability to make decisions for themselves. And let's say the doctor says, okay, you know, they're good, they can make decisions for themselves. I could see that being a situation where you could terminate the guardianship, because now they would do an evaluation of this person to see whether or not they've regained capacity. And then that would allow you to have a situation where now this person can make decisions for themselves and create a power of attorney for themselves.
Shout out for Lavera Shields. Also Marcus, my friend Marcus, live from my home state. Again, when you come in, do us a favor, give us a hashtag live where you from. If you're watching on the replay, give us a hashtag replay where you from. Also, this is going to be a 4-week series, so we're going to do this weekly at this time, 6 o'clock p.m. Central Time. This series on estate planning. For those that came in later, Sandy is an attorney in South Florida. She's an author. She's my friend, my sister. We actually met on Clubhouse. We connected, and we did a lot of rooms on Clubhouse. And I love her spirit. She's always trying to help and educate. So we really try to do some things together to be a blessing and to make an impact and educate people. Remember, this is for information purposes only. This is not she's giving legal advice. And Sandy's going to say she's not your attorney. Go ahead, Sandy.
Yes, I am an attorney. I'm a lawyer, whichever term you choose, but I'm not your lawyer. And I'm not even trying to serve in that capacity right now. I really want us to spend some time this month. This month is August, Make a Will Month.
Yes.
So all month long, we're going to be encouraging you to get your affairs in order and ask questions, share your thoughts and ideas, share your experiences, so that we can get folks to get their wills done during the month of August. So we'll be here every Thursday, 6 p.m. Central, 7 p.m. Eastern. Please, while you guys are on here right now, share this live. Invite others to join us right now. We're going to be on here for another, say, 30 minutes, Troy?
Yes.
Okay.
Let me, so I'm gonna pop this question up. Welcome, Monica, from Nashville, Tennessee, my hometown. Y'all know I got to represent Monica, represent the hometown. Also, Brenda Dean, one of the, I'm not gonna say that, Brenda. She's one of our church members. Brenda, thank you for being here. But I'm gonna pop this question up for Sandy. Lavera asked this question.
I want to create an estate for my family. How do I get started? So there's a couple of things that I want to touch on because this is an important question. One, your estate plan is yours. So you as the individual. When it comes to your family, there are pieces that you can incorporate into your plan for your family. But generally speaking, you're creating a plan for yourself. If you're married, they would create a plan for themselves. You all might have some joint things that you create together. If you're thinking about children, if you're thinking about your aging parents, all of these factors in individuals have to have their own plan. Now, as a family collectively, you can make some decisions of things that you all want to do as a family. As an example, not long ago, I had a call with a whole family. It was 4 married couples, and they just wanted to chop it up with me about estate planning. And they were even thinking of doing plans all together at one time so that they can, take advantage of some discounts or something like that. But these are things that you can do with your family, with your friends circle, collectively create plans. Now, you want to create a estate for your family. How do you get started? The first step is identifying what you have. And for this fact, Troy, I'm going to put up slides in just a moment. Okay.
All right.
So the first thing is you're going to have to identify all of the things that you have, all of the people that you are responsible for and that you want to be involved in your plan. And then you have to figure out what your intentions are, what it is that you want to happen when something happens to you. We used to say, if something happens, no. When something happens to me, like example, last night I was telling Troy, I'm sitting there having a good old time in my day and my blood pressure spiked low. I'm a little dizzy. Ambulance has to come check me out, make sure I'm okay. Thankfully, I'm okay. But imagine if I had to have a hospital stay. These are the reasons why it's important to have a plan, right? So the first thing to get started is organizing your information to figure out what are the things that I own and where do I want those things to go. And as well, if I have children or if I have other people that are relying on me, like my auntie, my uncle, my parents, sometimes distant cousins and relatives, or, those who have maybe disabilities or other things that we have under our care, we need to think about what we need for those people. Now, Troy, I'm going to go ahead and do the share now so that I can share that for Miss Lavera.
Oh, and we do have a couple of more questions. Glenn, I see your other question. I'm going to get Monica's first, Glenn. We'll come back to you. Welcome, Nicola. And I'm getting ready to share something from Sandy. Okay. All right, Sandy.
Okay, perfect. So I'm going to share something from a presentation that Troy and I did previously, mainly because it hits the things that we wanted to talk about in this live. And it also answers Ms. Lavera's question. Thank you for your question. So the number one thing that you would need to do is take an inventory of your estate. Your estate is everything that you own, everything. And you have to think down to the most minute of things. So as an example, Troy and I are both content creators. We have content in the social media space. Those are digital assets. We need to keep inventory of those things, because if we have any digital assets that are monetized, we need to make sure that we have those identified as we establish our plan. So the first thing, I'm looking at the people in my life. I start with establishing my family tree. One of the most challenging things that I have in going through probate and guardianship is oftentimes we have to fill out an affidavit to identify the members of the family. I can't tell you how many times people have no clue of full names of family members, have no clue if their grandfather or grandmother are living, or if, the names of grandparents, have no clue the names of their cousins. They might know first names or nicknames, but don't know last names. We need to take an inventory of our families, folks. And we should have a full out family tree so that we can make sure we are clear in identifying who's involved with us and who's not. Because I can tell you there's many stories of people who are like, so-and-so is my sister. Come to find out they were never siblings because they just happened to be, a child of one of their parents. And they weren't directly related to them at all. They had, sorry, not a child of one of their parents, but a child of somebody in the family. But they grew up together. So it was always like, oh, this is my sister or this is my brother, but they weren't actually siblings. So something to keep note of. Property. If you own property, any property, real estate that's for investing, real estate for your own personal use, timeshares, yes.
So I'm popping this, since you said property, I'm popping this question up because you can probably answer it in this.
Yes. If you have multiple homes, is it best to have each in a separate trust or all in one? I have heard both. Here's what I will say about real estate. Real estate is tricky because it depends on, is it real estate that you're living on? Is it real estate that you're renting for others to use? Is it real estate for Airbnb? Is it real estate for business? Because here's what happens. When you put everything in one basket, if something happens to one of the things in that basket, guess what? The attack will be on the full basket. So if somebody's suing you for something that happened in one property, but this entity owns all of the properties, well, guess what? They're suing the entity. That impacts all of your properties. So you have to be careful of how you organize these things, which is why it's important. You need to sit with an attorney, go over your specific circumstances to identify what is the best strategy for you, depending on your circumstances. But big picture, Miss Monica, I would say I don't like the idea of putting all eggs in a basket. I do like some separation when it comes to real estate.
Now, Sandy, you've got to mention your favorite quote.
Oh man, which one do I want to go with? Our lives are not fill in the blanks. We try to fill in the blanks all the time, but our lives are not fill in the blanks. We are not like, we can just take a form and put some information in and the circumstances apply across the board. What works for Troy may not work for me. What works for me may not work for my mother or my brother or my friend. Everyone's life has a little bit of a different nuance, and we have to think about those nuances and prepare accordingly with the proper professionals in place. Okay. Let me see. We talked about, yes, go ahead.
Glenn had another question. I wanted to get Monica because Glenn did ask another question. I wanted to get someone else in. So Glenn did have this question. Do you feel we should get a will or trust or both?
So I feel like you have to do what is best for your circumstances, and how I determine whether or not there is a will versus a trust or both is based on what your intentions are. So if, for example, your intention is to leave assets over generation to generation to generation, and you want to direct how money is spent and you want to direct how real estate is used, well, you might benefit from using a trust because that allows you to control your assets even after you've passed away. You know, how many times do we think of these big families, the Walmarts, the Sams, you know, these companies that have been around for a long time? Well, they likely have trusts in place that allow money to travel from this generation to the next, to the next, to the next. So my answer is it depends on what your intentions are. If you have adult children and you just want them to get their money now, once you pass away, a will might suffice. If you have other things that you want to organize and you have a very organized scheme of some things that you want to do from one generation to the next, well, you may want to consider a trust. And likely, if you have a trust, you're going to have a bit of a skeleton of a will. They typically call it a pour over will, or just a very abbreviated will that just says everything that I own is going to roll into my trust.
I'm enjoying the people asking the questions. That's what it's all about. You guys asking the questions, and we have the expert attorney here, Sandy, to answer those questions. And so if anybody else got any questions, feel free to ask the question, and we will definitely get Sandy to answer it. But again, I mentioned earlier, then we had the questions. Prince, DMX, Chasman Boswick, Aretha Franklin, all these people, they had money, and they did not have an estate plan, a will, or even a trust, whose fault was this, Sandy?
Wait, I think Aretha had one though. She had multiple, because didn't they
Right,
find one in the
that's right.
cushion?
Yeah,
Yeah.
she did.
So I find it hard to say fault. I think our community in particular, I can't speak of other communities, I'm going to say our community in particular, there is a lot of misinformation out there. There's a lot of lack of understanding of how our government works, how our transfer of wealth works, and how things actually happen if you become incapacitated. Sorry, when you become incapacitated or when you pass away. I've had so many times. So, my background, I'm Haitian. I can't count how many times I've done a plan for a Haitian couple and I've gotten the phrasing, oh, the government's going to take care of that.
Wow.
Because in Haiti, there are different rules under the Constitution that dictate the transfer of wealth or the transfer of assets. That's not the same here in the States. We do have laws that tell how things will transfer if you don't have a will. But trust me, you don't want to go through that process, because let's say you're married, you have a couple of kids, and you disowned one of your kids. You decided one of your kids, they can't do right. They don't want to do right. So you don't want them to inherit from your estate. But you didn't get to do your will before you passed away. Guess what? If you're married, number one, your spouse is likely going to get whatever you had. If you weren't married and you only have those two kids, well, no one's going to care that you wanted only one kid to get anything if you didn't have that ironed out. Because under our state law here in Florida, it's going to be split evenly. Also, an example, sometimes people are married and I can't count how many times someone comes in and they're like, I don't want my husband to know what I have, or I don't want my wife to know what I have. This plan is for me only. I don't want them involved. Well, here's the problem. If you don't iron out your plan properly, they may be involved and they may get it all, especially if you only have children with them. That's number one. Number two, here in Florida, if you own homestead property, you can't exclude them just because you feel like it. And you can't exclude minor children just because you feel like it. There are regulations about what happens when you pass away without a will. And there are some things that you can't do, like exclude a minor child or exclude a spouse, unless that person has identified that they've waived the right to that. And I'm not talking about the child, I'm more talking about the spouse. So it's important to understand that there are so many different tools out here that we can use. We just have to make sure that we choose wisely so that we don't end up in a process where our family has to spend more and waste more energy and, of course, waste more of your assets.
True. We got 3 questions that popped up. So the first one, Glenn, then Monica has another question, and then Marcus has a question.
So do either eliminate probate? So, and when we're talking about the either, we're talking about a will or a trust. So here's the thing. And this is always the funny thing why attorneys always say it depends. It really depends on the circumstances. Was the will properly prepared and executed? Was the trust properly prepared, executed, and funded? Second, was there a discrepancy or issue that might create a need for there to be some litigation with the will? For example, somebody contesting the will. Some question of whether you had capacity at the time that you drafted the will. Some question about you excluding somebody, and maybe because you had undue influence, like somebody improperly pushed you to create those documents. Maybe you didn't even have the ability to make those documents and they were fraudulently created. So there are some things that may cause you to have to go through probate if that will is not held up. And then when it comes to trust, I don't know if you all remember the Kobe Bryant situation. He had a trust in place. He had documents in place. He had a plan, but there was a whole issue with the baby. Yeah. And whether the baby was included when it came to this particular trust. So they had to go to court to establish that issue. And I believe it was later found that it was his intention to include any of his children, whether they were born later or not. And so that, I believe, was straightened out. I don't remember the Kobe case too well, but I do know that that was an issue. He did have a plan, but, things happen and that goes that route. So To go to this question of do either eliminate probate, it depends. Now, if they're done right, you can pretty much feel that probate is not going to be part of your path.
All right, we got a next question from Monica.
Should that be a revocable or irrevocable trust? So, side note, I don't deal with irrevocable trusts. Irrevocable trusts have other things that you need to be concerned about because they have tax ramifications. You need someone who is very much versed in tax. So don't go to somebody who just says, hey, I can create an irrevocable trust for you. You need to go to somebody who has a tax background to make sure that they do the irrevocable trust properly. Because an irrevocable trust removes the assets from your control. That's the thing that people don't understand. People think, oh, just make a trust. Well, it depends. A revocable trust is something that you continue to have control over. You can make changes throughout your lifetime and make adjustments and, updates and all of that. But the moment that you want to establish what's called an irrevocable trust, you're basically saying right now, I'm giving up the right to this asset because I want to designate it for this beneficiary. Example that I've seen is things for children. So maybe somebody's setting aside a fund for a child, and maybe it's coming from a life insurance policy or some other thing. And you're saying, look, I'm setting this aside now. I'm going to pay, taxes and deal with all that stuff now. But this is for this child, and this is going to be held until they turn 18 or 21 or whatever it is. So most of us here, including myself, most of us here are going to have an revocable living trust. And that trust is something that we're going to make adjustments to throughout our lifetime. Some of us may have irrevocable trusts, but usually that has to do with folks who have a substantial amount of wealth or that have some money that they want to designate now. And they're going to spend some money to do that as well.
Great questions. Got Marcus has a question.
If I retire in another state after I have set up a trust in another state, is there reciprocity that carries over to the new state? Now, what I'm going to tell you about these estate planning documents, no matter what state you're in and where you create them, oftentimes, no matter where you're coming from, you're going to bring your documents with you. Now, sometimes it will be suggested, especially if you stay somewhere long enough, to adopt whatever the laws are in your current state and get your documents redone according to that state's law. But if you're, say, a seasonal person or somebody who maybe has properties in different places, it's not a problem for you to have a trust that was set up in another state. But just understand the terms and conditions of your trust from your state may be different from the terms and conditions in this state, okay? So you'll be applying the law of the state that the trust was created in, okay? But if you're planning to retire somewhere else, my suggestion is generally, if you can, get yourself some new documents drafted up according to the state where you plan to live permanently.
Now, Sandy, I'm going to go back to something. Any other questions? Keep bringing the questions. Monica said, makes sense. Thanks.
Thank you.
I wanted to ask, and Marcus says, thank you. It's understood.
Okay, perfect.
Explain the trust must be funded.
Oh, that's a good question. So the trust is a document that basically identifies typically you as the initial trustee, and typically whoever, if it's your spouse or your children or maybe a close family member or friend as the trustee that's going to be in succession. Okay. So the successor trustee. What you're doing when you have a trust is you're identifying assets that you are setting aside for whoever your beneficiaries are. The thing is, you must fund the trust. So there must be an asset or a source of funding for the trust to be viable. So you can't just create the documents and just let them sit. You create the documents and you decide how you're funding it. A lot of times you'll see situations where folks will be like, they funded it with $100 cash or something like that. Not bad. It's still funded. Put the $100 somewhere, with the trust. Many folks will fund their trust with a financial account, whether it be a bank account or some kind of investment account. I've also seen folks fund trusts with real estate. And often that would be real estate that's like their primary home, not like a investment property or something like that. But in order for the trust to be effective, you must fund it. So if you create a trust and you don't fund it, you didn't create a trust.
Okay. So Sandy, with that being said, so when I set up a life insurance policy for someone, is it funded when they put the life insurance policy in the name of the trust, or when the beneficiary, when they pass and the proceeds goes to the beneficiary?
It's funded by whatever source that you've indicated. So if you go ahead and change the beneficiary on your life insurance policy and you state that it is, the Troy Holt Living Trust, that's the beneficiary, it is funded as of the date that you've created that change.
Gotcha. Okay.
Ooh, we have some good questions, guys. Thank you so much for sharing this moment with us. Please, if you are here, share this live. We would love to get more questions. We would love folks to watch the replay. And we want to encourage you. August is National Make a Will Month. We want you to make sure that you have created your will by the end of this month. Now, don't get me wrong. If you don't get it done, that's fine. But at least by the time you go through these 4 series, you'll be able to have the foundation set, and you can go to your attorney or whatever provider you have in your state to do so.
Sandy, back to our community.
Yes.
Why do you think we don't take care of these affairs?
Ooh, that's a loaded question, because I get so many different excuses. Because when I was at my peak of practice, when I was really spending a lot of time with folks and consultation and talking to them about their plans, and then you start to talk dollars and cents, I think one of the big things is folks think it's too expensive. But what folks don't realize is the price goes up if it's urgent. So here's an example. You have someone who has a hospital stay. The second they come out the hospital, now they want to create documents. But guess what? They want it urgently. So whatever you would have paid normally for your estate planning, you're not going to have to pay that fee to get this thing rushed. And it's probably going to cost you more, because the attorney will likely have to do what's called a capacity determination to make sure that this person is able to make decisions for themselves. And I know for me, I always end up having an attorney with me and a notary with me when I'm having the conversation with that person before I can create any documents. So I think price is a very big thing for many in our community, but I don't think we realize that we're in the age of technology, and there are like a million options right now that allow you to do this. Many of you have Legal Shield or legal help or legal aid, like whatever the programs are that offer you some level of legal service. Hey, it's not terrible. They offer you a foundational set of documents for you to be ready. Do it, right? Go to that attorney from that program and complete your documents. Also, as an example, I've started using, you know how you have a firm and you have pay later or pay in for? Well, they have that now for legal services. So you no longer have to take out all of your hard-earned money and drop it down for an estate plan. You actually can make payments over time through one of those Affirm type providers.
Okay.
So you have more options. And the last thing I would say is this. I lost my dad in January. I lost my aunt last July. I lost my other aunt the year before in January. It costs money to have a funeral.
Right.
And guess what? After you've spent all your money trying to put on a funeral and having the repast and the whole 9, well, guess what you're going to have to do now? Deal with their final affairs. And guess what you don't want to do? What I'm currently doing right now, going through probate for both of my family members. So if you don't want to increase the cost to yourself, it is much cheaper to do your estate plan. I do estate plans for way less than I do probate. My probate rates are double, almost triple what my estate planning rates are. Why? I'm working on documents versus going through a court process. It's a much different situation. I also think that there's too much information available on social media and on the internet that gives people a false sense of understanding. I went to 3 years of 4 years of undergrad and 3 years of law school. I had to take a licensing exam to become an attorney. Please, a Google degree. The Google degree is what I call it.
Right.
Your searches online and those free forms and the forms you can get at Office Depot or Staples do not replace the advice and counsel of an attorney. And I'm not telling you to come to me. I'm not telling you to go pay anybody. I'm just saying, if you're going to try to do it yourself, which many folks try to do, you may find yourself in a problem because you didn't study the law. You're going to see bits and pieces of the law, but you're not going to understand how the big picture comes together. And please understand that your mistakes in drafting documents won't be felt until after you've passed away. Case in point, Troy, the reason I came up with our lives are not fill in the blank is because I had a case very early on when I first started practicing. I've been practicing for almost 10 years now. I had a case very early on where it was a fill in the blank will. It was like from one of those like Office Max Staples stores.
Mm-hmm.
And literally the blanks were being filled in. But there was a section of the document where it looked like the person put a name and didn't have room to fill in the second name because there was like a couple of children and there was only a few children listed and they were missing one. So person comes to me, I'm representing them saying, look, Your Honor, the will is deficient. They didn't plan on excluding their child. We should be able to fix this. There's no issue. Come to find out, when we went to court, there was testimony by the witnesses to the fill in the blank will. And guess what the witnesses said?
It was intentional.
Mom was upset with son on one of the days, and I say son, but mom was upset with her child on one of the days and decided to write a new fill in the blank document, intentionally excluding son as a beneficiary. She listed him in the family section, but she didn't list him as a beneficiary. And that was traumatic.
Yeah.
Because all the judge could do was look over and say, well, I'm sorry, your mom excluded you and there's nothing I can do.
Yeah.
That was horrible. But that was an example of, yes, we can try to do things ourselves, but we don't know what those ramifications would be. I'm pretty sure later on, mom was okay with her son based on what I understood because they lived together. There was a whole bunch of stuff, but she never changed her document.
Yeah.
And so she passed away with an angry intention that happened at one period of time, passed away without changing the document.
Wow.
So now, if you had gone to an attorney or some other professional, they would have said to you, I really want you to think about this before you do any exclusions, right? They would have probably counseled mom about some of these decisions because we don't make decisions for planning out of anger or frustration. We make decisions for the long term, and we got to think carefully about what we're doing. Okay, Glenn, I love Glenn. He's giving me life tonight.
Do you remember Glenn on Clubhouse?
I do.
Okay,
I do.
Right. Okay. Hey, what's up, Mac? My friend Mac is here from Pensacola. Let me pop this question up because Glenn, he asking these deep questions.
All right. So how do we get more estate planning geniuses like you, Dr. Sandy? Why are there so few Black estate planning attorneys? How do we work with estate planning attorneys, offer life insurance funding? How can we assist them with pre-arrangement plans for the funeral protection against Medicaid spend down? How do we help people get prepared to avoid Medicaid spend down? So
I know you ain't gonna be able to cover all these in details today.
I'm gonna give you the big answer to this question. All of this comes down to education and awareness. And the reason that Troy and I are doing this August is National Make a Will Month webinar is because we want you to know that there are a number of Black estate planning attorneys. In fact, while we were on Clubhouse, we had developed a pretty big master list. So it's not like it was in the past where you can't find a Black estate planning attorney. Literally, you could Google Black estate planning, Haitian estate planning, Jamaican estate planning, whatever background you want, you can typically find someone in your zone. And if you can't, reach out to a local attorney. They often have a connection with someone who does something different. And then the other part that I would say to everything else that you listed, it's really just the education. And I say that to the exclusion of the misinformation that I see on social media. Anytime you see these videos where people will tell you, you need to have a trust, click away immediately, because no one needs to have a trust. You have a trust because you have an intention to do something that requires a trust. Education about wills. Sure, you could do it yourself, but you might want to pay someone to look over your document to make sure it satisfies what you want. And that would be at a nominal cost in comparison to creating a plan. But I see all the time, oh, you don't need to pay these attorneys. They're just trying to take all your money. Really? I'm trying to take all your money? I spend more time in probate and guardianship than I do doing estate planning. Actually, I spend more time doing estate planning webinars than I do actually working with clients on estate planning for the most part. Why? Because people wait till the last minute. And then when you're dealing with probate and guardianship is when you'll start to get folks saying, oh, I don't like the situation I just went through with my mom or my dad or my cousin. I got to talk to you now so I can get my plans done. So then you start to get the trickle. But the trickle doesn't come from straight out, I want to get my plans done. It comes from, they had an emergency. They had to deal with the courts. Someone was in a coma. Somebody had this, that, and the third. Oh my God, lawyer, I need your help. And then I can't help you then. Then I really can't help you. So Glenn, the biggest thing that we could do is educate. And I need folks to be discriminating in the information that they're seeing on social media, the information they're seeing on the internet. I need you to discriminate and look at information very critically, because there is no easy in this world of estate planning. There is no easy in probate. There is no easy in guardianship. If there's a court process, it's not easy. And if it's something that has to do with documents that will not take effect until you pass away, or do not take effect until something happens to you, please know that it requires some energy and effort to make sure that it applies to your circumstances. So, Glenn, education, key, and discriminate as much as you can with the information that you're receiving from different places.
And you know, Sandy, to your point, me and Glenn can probably testify to this too. Us being life insurance agents, it's a lot of misinformation out there, even in our industry. You know, sometimes people see a TikTok and say, oh, I can put money in this policy and then I can borrow from it. And I tell people this, I said, look, I said, you can't expect to put Volkswagen money, turn around a year later and get Rolls Royce returns. It just don't work like that.
Yes.
And, you know, and so people think, you know, they see these TikToks and they don't get all the information. And it takes sitting down and planning and calculating and figuring out what a person needs.
Troy, you're going to have to get a t-shirt. Volkswagen money doesn't get you.
Glenn said black people leave it in the shoebox for generations. That's true, Glenn. And that's then Monica got another question. Let me pop Monica's question up here. All
right, let's see what Monica says. What would you tell a person who only has one child about getting a will? I know here in Tennessee, I still had to go through probate, even though I'm an only child. Oh my God, this is the best question. So having a will does not mean that you don't go through probate. Going through probate has nothing to do with the will per se. Going through probate has to do with whether you have assets in your name only at the time of your death. If you have a will, you can identify certain assets that will transfer outside of probate. You also have certain assets that transfer through probate. So if I list in my will real estate, I can't transfer real estate from a will. I have to go through the court. The court has to approve the will and admit it to probate. And then the court is going to issue an order to transfer the property interest. If you wanted to avoid probate, there are deeds that you can do while you're living that will transfer the interest to that property, giving you a life interest in that property for as long as you live with the rights that you need. And then upon your passing, it has the language of who it is that you want to have that property upon your passing. So having that deed in place will prevent you from having to go through the probate process if it's done properly. And you're going to have to verify in your state what type of deed that is. Here in Florida, there's a couple of different names for it, but there are deeds that can allow you to maintain ownership rights in your property while indicating who your property will go to upon your passing. The second thing is understanding that a will is instructions to the court, it's instructions to your family, it's instructions to the world, like your creditors and all that, that says, these were my last wishes. That's why they call it a last will and testament. This is my last will. This is where I lived. This is my family. These are the assets that I own. These are the beneficiaries that I want to receive my assets. That's all the will does. It does not transfer interest in property. So if you have a bank account and it's listed in your will, like, I want my bank account funds to go to my daughter, well, guess what? You got to go through probate. The probate court has to enter an order approving the will. And then the court is going to issue an order saying to the bank, you must distribute the funds to this beneficiary. So notice you have a pass through there. How do you avoid it? Well, just like we had the deed for the real estate, well, when it comes to bank accounts, guess what we have? Beneficiary designations. They have terminable on death, payable on death. You must specify to your banker. I had a friend of mine who's a banker. She's like, they don't typically tell you to add a beneficiary to your accounts, which makes no sense to me whatsoever. But the bank is not focused on you having a beneficiary. Hey, the longer you have your money in there, they're going to continue to rack it up and wait for you to figure out the court process. So you need to have beneficiaries. You need to consider contingent beneficiaries if that's allowed with your bank, but you need to set it up so that if something happens to you, those funds can transfer to the person that you want it to go to. Otherwise, if you list that bank account in your will, we still got to go through probate because you have to probate a will. And if you don't have any assets that have a title or some other transfer that's necessary, for example, vehicles, boats, household furnishings, jewelry, artwork, a lot of those things, unless they're extremely expensive and rare pieces, a lot of those things will pass just from you having the will. It'll say, I want all these things to go to this family member or to my daughter or to my son. Okay? Somebody said, keep serving.
Yes, I just want to give a shout out to the president of American Classic Agency, Anthony Stewart. He popped on and said, keep serving. He's a great man.
Love it.
Appreciate him. He's always supporting me and the people. Mr. President, thank you for popping in and joining. Sandy, I have enjoyed you sharing these nuggets and this wisdom. Don't forget, y'all, next week, we're doing this each week for the month of August, 6:00 p.m. Central Time, 7 p.m. Eastern. Sandy, final thoughts, anything you want to add?
Ooh, final thoughts for tonight. So let me give you some homework tonight. Tonight, you're going to take some time to organize your information. I want you to think about all of the financial things that you have, any real estate things that you have, any names of people that you need to organize. And I want you to just get a notebook or get your planner or do it on your computer and create an inventory of everything that you own, everything you have an interest in, everything you potentially will receive as a beneficiary. I want you to list your family. I want you to do your family tree and work out the details of who are the people that are closest to you and who are the people that are at a distance, and get those names and addresses and phone numbers. And I also want you to think about your intentions. What do you intend to happen when something happens to you? Think about incapacity. Think about passing away. If I was rushed to the hospital right now and I can't do anything for myself, who are the people that should be stepping in? What are the responsibilities that I have that now need to be handled by someone else? Like, someone needs to call my job. Someone may need to do pickup of the kids. Someone may need to notify my organization that I'm not going to be there because I'm the leader. You know, those things have to be done. So this week's assignment, organize your information. If you need any help with it, drop something in the chat and I'll add any pointers or tips. But please share this live. Invite a friend or family member to join us next Thursday, 6 p.m. Central, 7 p.m. Eastern Time. August is National Make a Will Month. We want to help you make a will in the month of August.
Awesome. Glenn said, make sure you include Dr. Sandy's Cash App because she's dropping some serious gems. So she sure is, Glenn.
Look, hook me up. I got to send my nephew back to school next week. So, Auntie's pockets are going to be drizzling out. Lord have mercy.
And one of these two, Sandy, I want us to kind of talk a little bit on, thanks, Destry. Talk about special needs planning from the state part, but then also, there's a component, a financial component that we can come in and help assist. Hey, Melissa. Melissa has a agency, Medicare insurance, a young lady in the I think she's in North Carolina now, doing some great things. So thank you, Melissa. Thank you, Destry. Destry also always support me. Look, I can go on and on. I know Sandy got to go. Y'all meet us next Thursday, 6:00 p.m. Central, 7 Eastern. All this month, Make a Will Month. Bring your questions, invite people, share this live. Looking forward. Thank y'all for your questions. Thank y'all for your support, for being here. It's truly, truly appreciated.
Thank you, guys.
Bye.
Bye, everybody.
You're welcome, Joy. Thank you, Joy.
Oh, this was great.